All right, I want to welcome everybody to today's webinar. This is kind of a special bonus, special treat that as I've been in the Facebook group a lot lately and just with the different comments and things, people have been asking a lot of questions about protecting their brand. And as we've had people grow and develop throughout the Head Start course community, people are starting to add multiple products and build brands. And I think when you get to a certain stage, it's really important to start thinking about what you can do to not only protect your asset, but continue to build it and grow it itself, as well as protect others from taking your valuable work. So what we have today, we have Suzi Hixon, who is going to talk to us. She's going to be our special guest. Suzi is an intellectual property attorney. She's also an Amazon seller. And so she does this just like all of us. And I had her come on just to be able to talk about things from a legal perspective. And this is something that this is a little bit, I went over a little bit earlier what she's going to talk about. And I think this is really, really valuable stuff. And I think if you incorporate some of this time that we're going to spend today is going to be very, very worthwhile. So with that said, let me go ahead and introduce Miss Suzi Hixon, who is an intellectual property attorney. So Suzi, how are you today? And welcome.
I'm doing well. Thank you so much, Mark. You doing okay?
Doing fine. I will have to tell everybody, for those of us in the United States, to know that I'm a big college sports fan. And I have to tell you, I almost kind of nixed Miss Hixon here when I asked her. She said she lives in Kentucky. So anybody knows I'm a big ACC conference guy. And the first question I asked her was she Louisville or Kentucky? And she kind of hedged a little bit, kind of really wondering where I was going with the question. But then she said Kentucky. And I'm thinking, well, okay, I'm an ACC guy. My wife and daughter, they had to go to SEC schools because they couldn't get in ACC schools. So then she said Kentucky up here. And I about cut her off right there. But I thought, no, let's let her go through and talk a little bit because she probably knows a little bit more beyond the basic stuff of sports rivalry. So with that said, Suzi, we're glad you're here and welcome. So if you want to get started, let's go ahead and jump in. But I will say to everybody, what let's do, she goes through this and inevitably questions are going to come up. So we've got a period set aside for questions and answers at the end. So if everybody would hold their questions until the end, we'll get to all of them before we get out of here. So with that said, again, Suzi, welcome, and let's get started.
Let's get started. Thank you again, Mark. But I will have to remind you that I did say that I just went to law school at UK and that I'd lived in Louisville and was,
All right, that's why I gave you half credit.
Yeah, that's why you gave me a little bit of pass. So. Well, thank you again, Mark, so much for giving me the opportunity to talk with a lot of your listeners and followers about intellectual property. And, I'm coming at this from very much an intellectual property standpoint, but as I dig into the issues that private label sellers face, I see that, hijacking is a really big issue right now, and, having rogue sellers on your listings. And I realized, that being able to protect your brand and your trademark from a proactive standpoint will actually help you in the long run when it comes to dealing with these hijackers. So this is what you're going to learn, I hope, in the next 30 or so minutes. A pretty good overview, I hope, is how to determine the intellectual property assets of your private label brand and whether or not you have these assets in your business. And hopefully I can kind of help you identify private label assets that you might have. You'll also learn why you should protect your brand by registering your trademark with the USPTO. You're going to learn how to proactively prevent hijackers from jumping on your Amazon listing. Of course, there is no silver bullet here, but I hope that this is going to be a little bit of ammo for your arsenal. We're also going to learn how to proactively build the strength and value of your brand on and off of Amazon. A lot of the tips that I'm going to be giving to you today are definitely going to be applicable to not only your Amazon listings, but also your e-commerce site if you have one, and in general, your overall brand protection strategy. I've got some strategies that your competitors probably aren't implementing, and hopefully these will help you step up your brand protection game. And finally, if we have a little bit of time, I'd love to run through a few rookie mistakes that I see sellers and just entrepreneurs make in general with respect to their intellectual property. Just briefly about me, I've practiced intellectual property for over 13 years. I graduated from the University of Kentucky, sorry, Mark, in 2003. And I guess the time flies when you're having fun. I've prosecuted over 600 trademark applications with the United States Patent and Trademark Office. I have practiced patent law. I'm a registered patent attorney, although I do not currently practice any patent law. I'm focusing my practice very much on branding and trademark specifically. And last year, I started a private label myself on Amazon. And the reason that I did this was because I had a client who was doing it. I had no idea what he was talking about. Of course, I knew what private labeling was, but the whole Amazon platform was very new to me. So I knew that for me to really be able to help him, one of the best things I could do would be able to get my hands, dirty and get in there and do it myself. So that's how I initially was introduced to private labeling. And finally, I'm an auntie, dog lover, book nerd, chicken herder, and goat mom. I live on a farm in Kentucky, and I work remotely. So that's a lot of fun.
I want you to elaborate on the chicken herder thing, because to me that's just funny.
Well, yeah, I think 13 chickens. And at one point, we never, it kind of fluctuates. When you live out in the middle of nowhere, you might have coyote problems, I have some hawks and things like that. So at any one point, we have between 10 and 13 chickens. We've got a few roosters, and we love fresh eggs. So it's, if you're in a place where you can possibly have like your own chicken coop, of course, if you live in a neighborhood, you need to make sure you're zoned, but having chickens has been one of the greatest just life improvements. I know that sounds really weird, because 50 years ago, people kind of balked at having chickens, but getting to have your own fresh eggs is just awesome. So
yeah, I think that's a good story.
Highly recommend it.
But anyway, sorry to interject there, but to me, that's just, you don't come across many chicken herders.
No. But they're fun. They're a lot of fun. And if you have a couple goats, and they're a lot of fun too, but they're not very smart. So just a warning about those. I think the chickens are about as smart as the goats are.
Right.
Okay, so you as a listener, probably already have intellectual property assets for your private label business that you might not really even be thinking about. And these assets that you own can be considered ammo in your arsenal against hijackers or rogue sellers. You'll hear me use both of those interchangeably. So let's talk about some of the types of intellectual property. A brand itself isn't necessarily a type of intellectual property. I like to consider it an umbrella that includes things like copyrights and trademarks. But you will occasionally hear the words brand and trademark used interchangeably, and that's not completely accurate. So what a brand is, it's a set of promises made by a business to its target clientele. And the brand makes it easy for consumers to identify the product, as well as any other brand values that a company promotes or promises. So these brand values are associated by the consumers to the brand, and they are often prepared to spend extra money for branded products and the reassurance that branded products provide. So anytime someone tells you that your brand doesn't matter, they are so very wrong. I hear this occasionally. People say, oh, it doesn't matter, just throw a brand on there, it doesn't matter. In the eyes of the consumer, it matters. Brands consist of several components. It could be your company identity, images, your brand culture, the essence, the look and feel of your brand, including the packaging and presentation. The tone in the copy of your website also contributes to your brand. So think about a company like Apple. What kind of feeling does that make you have? What type of emotion does that conjure up in you? That is a brand. Of course, the Apple's trademark would be iPhone, the word Apple, their Apple logo. Two types of intellectual property that I'm not going to touch on at all in this seminar is trade secrets and patents. They're a bit outside the scope. Patents are a little more complex, and I don't think that they're really applicable right now. So copyrights specifically, Copyrights are a form of protection for original works of authorship, including pictorial, graphical, and audiovisual creations. So copyrights can also be a component of your overall brand image and your message. For example, the tone that you use in Amazon listing copy can actually hint at your company's overall brand message. For example, is your brand playful and whimsical, or do you have a more serious brand? So some elements of your branding that could be subject to copyright protection include your listing content, the look and feel of your e-commerce website, your website copy and images, advertising collateral, copy and images, and product photos. So a copyright will last the life of the creator plus 70 years, and it's not renewable. If you want to learn more about copyrights or file a copyright application, I've listed the website right here, copyright.gov. So keep in mind that copyright protection does attach at the moment of creation, but to actually enforce a copyright, you will need to have it registered with the Library of Congress. And you can do that at the website that I've given you here. So trademarks, what are trademarks? Like I mentioned a minute ago, a trademark is just one component of your entire overall brand, just like a copyright. Trademarks are source indicators. So for example, let's say you're driving down the road and you come to a red light and you look over and you don't even see the car next to you, but you look down at the rims of the car and you see a white and blue kind of square logo in a round circle. You're going to probably immediately think that the source of that vehicle is a BMW. So that is how trademarks work in their most basic sense. Trademarks will last as long as they are being used. As an example, Stella Artois, the beer, that is a mark that has claimed use since 1366. So the function of trademarks is really twofold. The first thing is that it builds brand value. They build brand value for your company, and this is something that helps you as a brand owner. The second function of a trademark is that it builds brand recognition, and this is something that really actually helps the consumer. So keep in mind, a trademark is just one component of your entire brand. I have a fun hijacker prevention pro tip here. Brand your product and or your packaging. Add your trademark to your packaging and or your product. This is one of the #1 ways to prevent hijackers from jumping on your listings. Include a branded booklet and or information card along with your product that you're selling on Amazon. Do not be an easy target for hijackers. Like I said earlier, there's no silver bullet, and you have to take proactive steps to prevent hijackers. But this is one step that you can take that's going to make it less of a chance that you'll be a target of a rogue seller. Now, another thing is you can show your branded packaging and booklet on your image listings on Amazon. Mention within your listing content to look for your trademark and branded packaging. And I'm using the words look for in quotes. You might think that you don't want to spend money on your trademark and branded packaging like this, but let me tell you that spending money on the proactive protection of your Amazon listing by spending this money on awesome packaging and a totally rad trademark is going to be a lot more fun than spending money on an attorney later on to help you. So put your money and your time and energy towards something positive for your business, and that's developing that brand from the outset. The cool packaging, the trademark, and even an associated design or logo or a tagline. And again, I'm going to harp on this. People say the branding doesn't matter. It matters so much. My position remains that you need to focus your time and energy on this. This is very important. And remember, Amazon does not get involved in trademark disputes. However, Amazon does get involved in counterfeit product issues, and I'm going to talk more on this in just a little bit. But doing this at the outset, doing this branding at the outset, well, one, it will prevent the hijackers. Two, it's going to make them easier to get them off of your listing. And three, in the meantime, you are going to be building brand recognition on and off of Amazon. Here are a couple of really good examples, I think, of branded packaging. First of all, we have our Altoids. You see the branded, the overall branded packaging in the trademark Altoids. And then in the other example, I have the little blue box that many of us know exactly what it is. The second we see it under a Christmas tree, we get very excited. That is branded packaging, and there are a couple of trademarks involved right here. One trademark, of course, is Tiffany & Company. And did you also know that that color, that robin's egg blue, is a registered trademark for Tiffany & Company? So you can also possibly get colors registered as a trademark. And another example of a company that has really used color as part of their marketing and their branding is UPS. And believe it or not, they have brown as a registered trademark for their services. Okay, next slide. So one of the most common questions I get about branding and trademarks is, why would I even want to file a trademark application with the USPTO? Why would I want to register my trademark? So there's actually a lot of reasons for wanting to do this. First of all, the R in the circle, once you get your mark registered, you are permitted to use that in your copy and within the content of your Amazon listings. This should act as a no trespassing sign, and it does put others on notice that your mark is registered. Second, being on the Federal Register of Marks means that your mark can be used as a basis of a likelihood of confusion or rejection for subsequently filed trademark applications that are confusingly similar to your trademark. Number three, your trademark and your registration is an asset for your business, just like any other tangible asset that you have. It holds value and it can be sold as an asset with your business. So if you have a private label brand and you have a registered trademark for it, at some point you may want to sell that brand of your business. And having that federal registration shows to potential buyers that you are business savvy and that it will add value to your private label brand as a whole. And fourth, having a registration gives you the ability to license the mark if you're considering another income stream. Your registration shows that you have presumptive rights to that mark on the goods and services throughout the U.S. So let me just talk really briefly about a jurisdictional issue. When you get a registration with the USPTO for your trademark, it is only for the United States. If you're selling your products via Amazon in Canada and I guess it's Mexico right now, you may want to consider filing in those two jurisdictions as well. Having a registration will help you get on the Amazon brand registry. It's not required. And finally, I'm going to talk more on this in a bit because I think it's super important and totally underutilized, but if you get your mark registered with the USPTO, you can record that registration with U.S. Customs. And where this really comes into play is when you're dealing with the import of counterfeit goods. And so hopefully our customs agents will find counterfeit goods at the border before they even get imported into the U.S. When you're dealing with China, as I'm sure many of you all have, actually getting a registration and enforcing a registration in China can be a complete nightmare, super expensive, and at the end of the day, it's very, very difficult to enforce a trademark in China. So one of the best things to do, in my opinion, is trying to stop the import of counterfeit goods into the United States at the borders. Another common question I get is, should I even file with the trademark my trademark with the USPTO? So I've shown you the benefits, and we all know that there are benefits, but are you really ready? You're probably asking yourself that. So I like to give people Three things to really think about when they are considering whether or not they want to actually, go through this application process. So the first question you need to ask yourself is whether you consider that trademark as an asset to your company. Do you consider it an asset, just like your products and just like your laptop and any of the tangible items that you use on a day-to-day basis to keep your business running? The second thing I think people need to ask themselves is, how would you feel if you saw a copycat or if you saw someone using your mark? Having an emotional connection to your brand is totally okay, and I want to make a point of that because I know a lot of people don't want to mix emotion with business. I get that. But what you're trying to do with your brand is you want to invoke some type of emotion out of the people that see your brand. So for you to have an emotional connection to your brand is totally okay. And the more of an emotional connection that you have, then you should kind of err on the side of filing a trademark application. Because, 6 months down the road, a year down the road, when you see someone infringing your mark, you're going to have ammo to send them a cease and desist letter. And the last thing people need to ask themselves are you ready, willing, and able to enforce the mark and the eventual registration if you need to? So keep in mind that registration of a trademark is only half the battle. You have an obligation, once registered, to actually enforce that trademark against infringers. And this protects not only you, but also consumers. If you don't enforce your trademark rights, you could eventually lose your rights, period. And if you have no interest in enforcing it, then there's no need to file. Some of the things that you need to kind of substantiate whether or not you're ready, willing, and able is you're going to have time, or you're going to have to outsource your time for monitoring, and I'm going to go into that in a little bit. You're going to need to have the funds to do it. Filing the trademark application, like I said, it's only half the battle. You're going to have to enforce it if necessary, and you're going to have the gumption to do it. You can't sit back and think, oh, I'm too afraid to send off the cease and desist letter. What if? You're going to have to be strong and get behind your brand and your trademarks. Another big question I get is, what about timing? When do I file my trademark application? Of course, you need to ask yourself, where is your company financially? And are you confident in your branding? If you think that, you're not really quite sold on your brand, you're not happy with it, you don't really like your trademark, put it off. But once you are confident with your branding, you want to file a trademark application sooner rather than later. And I want you to remember this mantra: being proactive is less expensive than being reactive. I promise you, if you take the steps at the outset, you're going to be so much happier. You're going to go to sleep at night better. You're going to, wake up knowing that, you've done everything you could to protect your trademark and your brand at the outset. So what happens after you file with the USPTO? This is a little bit longer process than a lot of people think, but I'm going to just list two of the big hurdles that applicants have to overcome as they're going through the process. Keep in mind that the application process is going to last at least 6 months, and there's a good chance that your application won't even be picked up by an examining attorney to be examined for at least 4 months after application. So just go ahead and put yourself in the mindset that that's kind of how this works. And that has to be, that's because there's such a backlog at the trademark office. It just takes that long for them to actually get to the application. So your first hurdle is that your application will be examined by the examining attorney, and he will review it for procedural issues. This includes, whether or not a disclaimer needs to be entered, whether there needs to be a clarification of the goods description. These are typically very basic issues that can be addressed that, you don't really need an attorney to help you address procedural issues. Now, substantive issues that an examining attorney is going to look at, these include likelihood of confusion issues and descriptiveness issues for marks that are applied for. And sometimes when responding to these types of issues, it does serve you well to hire an attorney who can help you respond and can draft the appropriate arguments to help you overcome rejections. After your application is examined and the examining attorney says everything appears to be in order, let's move it on to the next phase, the next hurdle is that it is published for opposition in the official gazette at the USPTO. And this is when third parties are given an opportunity to oppose your application. So at some point, assuming that you've addressed all the issues by the examining attorney, and you've gone through the opposition period and there were no oppositions filed against you, you will eventually have to show the examining attorney that you're using the mark in commerce. So just keep that in mind, that you can file a trademark application on what's called an intent to use basis if you know that you're going to eventually put it into use, but you still have to ultimately show that you're using the mark before you can actually get your registration certificate. So let's talk about protecting the overall value of your private label brand. You don't have to start working on protecting the value until after you get your trademark registered. So keep that in mind. It's something that you need to be thinking about at the very outset. And there are two major facets for protecting your brand value. First of all, you need to proactively monitor your brand. And second of all, you need to be ready, willing, and able to send those cease and desist letters if you need to. So trademark monitoring, I hope I'm providing some good resources here for you. You'll hear it also referred to as watching and policing. And there's a couple of ways that you can go about that. There's a cheap method, and it's you doing it yourself. You put it on your calendar to check these resources every month or 2 weeks or however you feel comfortable doing it. You can set up a Google Alerts for your trademark. Of course, you're going to want to manually check your Amazon listings consistently. You can utilize USPTO.gov. There is a trademark searching platform on there. It's a little clunky, but you can use it. And there's two other resources, Noam and NameCheck, that you can use to just periodically see if there's a similar mark to yours being used out there. Now, there's also the more expensive method, and this is a much more robust way of monitoring your brand. This is an outsourced method. It's very extensive and comprehensive. You can use a company that, like I use, called CompuMark. It's a division of Thomson Reuters, and you can set up your mark with their trademark monitoring service, and it typically costs $300 and up annually to monitor your mark, and the cost will vary based on the extensiveness of your search. So just kind of keep that in mind. That's a really good resource. A resource that I haven't used yet, but I've heard about recently, is Wiser.com, and this is apparently supposed to be really good for monitoring MAP agreements, minimum advertised pricing agreements that you may eventually have with resellers. It might not be particularly applicable right now, but it is just one of those little things that you can do to help you maintain your brand integrity. And maintaining certain prices is definitely one of those little things that you can do to help you do that. So let's talk about cease and desist letters. First of all, make sure you are in fact the first user of the trademark. There is due diligence that is needed in this situation. I have come into situations in the last 13 years where I've been on the receiving end of the cease and desist letter, and we found out that we were actually the first user of the mark. It can obviously complicate matters for the sender because you are, telling the other party that your marks are confusingly similar. So just be very careful of that if you do send off a cease and desist letter, to make sure that you are indeed the first user of that trademark. I strongly encourage anyone who does a cease and desist letter on their own to not bully the other party, and to be very careful about your initial tone, because what that does is, if you take a really aggressive stance, the other party is going to possibly respond aggressively. So I think tone is very important when it comes to cease and desist letters. There's also the risk of the other party or the recipient putting that cease and desist letter on social media, and when that happens, a completely uninformed public gets alerted to that, and they're going to start, they could start harassing you. So just be very careful about setting tones, and just making sure that you're the first user of the mark. You may want to get an attorney to do your cease and desist letter. And the reason I do suggest this, usually there are exceptions, is that you really want to create this perception of risk to that violating seller. And when they see it's from an attorney, they're going to be more likely to realize that proceeding with with a counterfeit item is much riskier. So let's talk about strengthening the value of your private label brand on Amazon and beyond. So to strengthen the value of your brand, you have to keep hijackers off your listings, or you have to get rid of them as soon as you find out about them. Keep in mind that there, again, like I said, there's no silver bullet, there's no hack, but it does help to have a proactive branding strategy. Now, let's talk about Amazon's role in brand protection. They don't get involved in third-party disputes. They don't enforce detailed page ownership and image restrictions. They don't enforce exclusive or selective distribution agreements. They don't get in contracts between sellers, and they don't enforce trademarks. But there is a big exception here. Amazon does want to get involved if there's a counterfeit issue. And this is all about consumer protection. That is the policy behind Amazon's anti-counterfeit policy, is protecting the consumer. Their policy specifically states that customers can always buy with confidence on Amazon. Products offered for sale on Amazon.com must be authentic. And that the sale of counterfeit products, including any products that have been illegally replicated, reproduced, or manufactured, is strictly prohibited. So precedent has illustrated that third-party platforms can be brought into major lawsuits for selling counterfeit items on their website. And I'm not going to go into detail about this, but there was a really big case several years ago where Tiffany sued eBay. Tiffany Company sued eBay for the sale of counterfeit items on their website. So keep this in mind. Amazon's not going to proactively protect our brand for us. This is something you're going to have to do on your own. But as sellers, we can benefit from Amazon's proactive anti-counterfeiting policy. So what do you do as a seller? You proactively monitor and police your trademarks on and off of Amazon, which I've mentioned before, and you periodically review listings. Follow the links at the bottom of your listings to see if there's any other sellers on there. Now, of course, we usually know if someone jumps on our listing. We could lose the buy box. We could see a loss in sales. We see someone undercutting us. So a lot of times you're already going to know if that's going on. I am not going to go into a whole lot of detail just because we're a little pressed for time regarding those cease and desist letters. And I know that I talked a minute ago about setting a proper tone. Be nice at the outset. Give the other party 48, 72 hours to respond. Be ready to ramp up the aggressiveness in that amount of time if you need to. So let's talk about reporting counterfeits to Amazon. This is the bane of, I know a lot of sellers existence here. The whole, you must do a test buy the alleged counterfeit product before you can do it. You know what? Do the test buy. Just do it. You can ask for a refund from Amazon. This is something that you must do. If the product is found to be counterfeit, Amazon will reimburse you for that, and we wouldn't be doing it if we didn't think that it was counterfeit, or we were pretty darn sure. While you're waiting for the counterfeit product to come in, go ahead and complete that infringement reporting form. Now, you might get a response back from Amazon saying, hey, we're not going to do anything because we need to have, images from your test buy. But go ahead and respond or explain to Amazon that it's going to take like 2 or 3 weeks or whatever it is for the product to come in from China, and in the meantime you're suffering damages, and that you're going to win anyway. Now, there have been some instances where Amazon will do this. You know, they'll go ahead and remove the seller. Not always, but it happens. So let's talk about some other ammo in our arsenal here. The brand registry. I think that there's a lot of confusion with the Amazon brand registry. I've mentioned this before. Your trademark registration is not required. It will help. These are some of the things that the brand registry does not give you. It's not going to prevent other sellers from selling your product, even if you are the brand owner. It's not going to block sellers from buying the same product from a manufacturer. It's not going to make Amazon responsible for any type of trademark infringement, and it's not going to guarantee you an automatic buy box, okay? So the purpose, though, the intended benefit of an Amazon brand registry, this is the most important. It gives registered sellers more authority over listing content, such as titles, details, images, and other attributes. So here's where it's really important, okay? Within your content listings, you're going to be able to put your look for language. You know, look for the branded the branded packaging. Look for our trademark when you receive our product. You know, we have this warranty that we're offering with our product. These types of things you're going to have control over in your listing. So that's really important. It's important ammo. It's going to help Amazon shut down some counterfeits, and you're going to also be given a GCID. So how do you get on the brand registry? Of course, only the following types of sellers can enroll in Amazon's brand registry. It must be the manufacturer or brand owners, and that would probably be you as private label sellers, as well as distributors, resellers, and other individuals or companies who have the written authorization from the manufacturer or brand owner to manage a brand's content on Amazon. So this is something I think that's really important. Here are some tips to increase your chances of getting on brand registry. Create an easy e-commerce website. You can do this in a day. Have your branded products on there, your product picture, show your packaging. It's also suggested to use a proper business email address and not something from Yahoo or Gmail, but actually a business email address that has your domain name in it. You're going to want to submit product packaging with your brand visible, images of your product with the brand visible, and unique key attribute in association with that product. So once your application for a brand registry has hopefully been approved, Amazon will have assigned to you a GCID, and they'll assign one to every SKU you included in your application. Since each GCID is unique, it's now going to be much harder for a third-party seller to actually change your content. And I've listed here where to look for your GCID because it's not very intuitive in my opinion. U.S. Customs, this is what I was talking about earlier that I feel like is highly underutilized, but it's something, you know, it's actually a little bit more advanced form of protection for private label sellers, but I want this to be on people's radar and sort of a goal to work towards. This is, like I said, this is all too often overlooked. Basically, the Customs and Border Protection, they work to keep foreign pirated and counterfeit goods from actually being imported into the U.S. And just as something else for you to think about, that the trade in these illegitimate goods is associated with smuggling and other types of criminal activity and often fund criminal enterprises. So the CBP protects businesses and consumers every day through their very aggressive intellectual property rights enforcement program. So recordation is the process of submitting your IP rights or your IPR information to CBP. And again, you actually have to have a registered trademark to be able to do this. Once a company has a registered trademark, it really needs to consider the step of recordation with CBP. So what's it like working with CBP? This is pretty easy. You record your registered trademark with CBP, and after you've recorded it, you need to proactively educate CBP about your trademark and your intellectual property rights. Now, if you go to the CBP website, and I haven't listed it, and I apologize for that, it's iprr.cpb.gov. You'll learn about how to actually continue to educate CBP about your trademarks, and this is a very important step. You also need to keep CBP updated if there's any changes, and you also need to be ready to report suspicious trade activity and any counterfeit items that you see. So do your part also as a consumer to help fellow brand owners if you do come across counterfeit products. And I'm going to harp on this a little bit. I loathe seeing counterfeit products out there because I know how much money brands spend to protect their brands and to increase the value of it. And it's sad almost to walk down the street in Manhattan and go to Canal Street and see all these knockoff purses. It's pretty terrible. But keep in mind that the trade in counterfeit and pirated goods threatens America's innovation economy, and that's really what it comes down to. It threatens the competitiveness of our businesses and the livelihood of U.S. workers, national security, and even the health and safety of consumers in the U.S. and abroad. A few tips here. I know we're coming about 15 minutes till 3 about protecting your brand. A few things that your competitors probably aren't doing. These might be a little more advanced steps, but these are things that should be on your wish list. Okay, something to look forward to as a brand owner. As your company grows, and these are things your competitors probably are not doing. First of all, develop a brand manual. The reason you want to do this is it promotes consistency and brand cohesiveness for your overall brand and your trademarks. And because what you really want to do is you want to give people a brand tattoo. Like you want consumers to, just immediately when they see your brand, have a certain feeling and know what that brand stands for. I know if we look at a Starbucks logo, many of us are going to have sort of an immediate emotional type of connection somehow to that. A brand manual will include the rules about your brand, the Pantone colors that should be used, proper uses of your logo, the tone of voice, the use of words, how your copy should be written on Amazon listings and on your own e-commerce website. And again, this really goes into just hammering in what your brand is overall, making it more difficult for hijackers and rogue sellers to jump on your listings. Another possibility is considering sterilizing your products. Now, this is something that's going to be more expensive, but it's something that you might want to think about at some point. Apply to the Amazon Exclusives program. This is kind of cool. Now, there is, Amazon does charge an additional 5% referral fees, but you will get more brand representation and protection by Amazon. They're going to also enable video and additional HTML on your listings page, and this will help you differentiate your product. And then in addition, it's going to create barriers to protect your brand and listings as your profile on the Amazon platform grows. And then finally, there's the brand gating and brand restriction. We all know Samsung, Nikon, Microsoft, Cards Against Humanity, some frozen products. These are all brands that are gated or restricted. And one thing that you can consider doing as you become a stronger brand over time is actually applying to become a restricted brand on Amazon. This is going to take more negotiation and more internal contacts with Amazon, but it's possible. Mark, do I have a few minutes to run through some rookie mistakes?
Yeah, we're fine. Keep going. This is good stuff.
Okay, let me take a little drink here of my soda. Okay, rookie mistake number one, failing to think outside the branding box. Failing to really think about what elements of your brand are actually trademarks. And I mentioned this earlier about how Tiffany and Company uses the robin's egg blue color on their packaging, and that's a registered trademark for Tiffany and Company. You know, so really think outside the box when it comes to your trademarks. You will be blown away at the types of things that can be subject to trademark protection: colors, sounds, jingles, the lion's roar before an MGM movie, that's actually a registered trademark. So really think outside the box. I see a lot of times people will file a trademark application with the USPTO and they'll improperly list the goods, or they'll list the goods in such a way that it unnecessarily limits the scope of their protection. So be very careful with that if you are going to file a trademark application on your own. If you get a rejection at the USPTO, don't just let the application go. Either respond to it yourself or hire an attorney to do it for you. Just because you get a rejection doesn't mean that you can't get your mark registered. Okay, so don't be afraid to be aggressive and to respond. Note that if you do get a rejection, you have 6 months to file an office action response. So if you go on your own, you're not using an attorney who's going to docket it for you, make sure that you do calendar that so you don't let a deadline slip by. Another rookie mistake, I see a lot of people using improper notice symbols. The R in the circle is for registered trademarks only. The TM can be used for marks that are pending, or even marks that you haven't even applied for yet. So that's a common misconception. You don't have to have a pending application to be able to use the little TM symbol to give third parties notice of what you're claiming as a trademark. So just a few more here, and I mentioned this earlier, recording with the CBP and not doing anything else about it. One thing that's really important, if you do record your registration, your trademark registration with the CBP, is to be very, very proactive in educating CBP about your trademark. So they'll know what to look for when products are being imported into the U.S. A common mistake I see a lot of times is inconsistent use of a trademark. If you do not consistently use your trademark, it can make it subject to cancellation of the registration. So don't, if you're using two words, don't sometimes put them together, don't sometimes put a space between them, don't sometimes put a hyphen between them. Like, always consistently use your trademark. Don't throw in an S if you feel like it. This is really important. It's important in really establishing that brain tattoo also. If you fail to monitor and you fail to enforce your trademark rights, again, you can lose your rights. So you need to be proactive in monitoring. You need to be proactive in enforcing. It's not, you know, like I said, it's not one and done deal when you get your registration. It's just part of the battle here. Be very careful, again, with sending cease and desist letters without first doing your due diligence to make sure that you are, in fact, the first user of the mark. I've given a resource here that I use a lot to help me do that. Of course, you can do your own internet searching, but marksman, doing a marksman investigation is a great way to really kind of decrease your risk as you go forward with a cease and desist letter. They'll basically do searching for you and try to determine anonymously when the other party first started using their mark, so you can be sure that you were the first user. And that concludes. So just be mindful that brand policing and protection on Amazon is not a quick fix. It's an ongoing effort, and you know, even though you're spending your resources now, remember that you're increasing the value of your overall brand through those proactive efforts on and off Amazon. And Mark, I do just want to say that I do have a 15-point checklist of strategies that a lot of them are kind of included in this presentation, but maybe a few more that if anyone would like to have a copy of, they can email me here and I'd be happy to give it to them.
Okay, wonderful. What I'm going to do is I'm going to switch back to me as presenter so we can see the questions, and
okay.
then we'll be able to take those. So one, like I said, gosh, that was really good information, Susie. Thank you for all that. I mean, because again, obviously this is a big issue, and a lot of things I took away from that, and of course, really, obviously, prevention is a whole lot easier, and as you said, a whole lot better than having to fix it after the fact. And the other thing about dealing with things at the customs, I mean, because again, obviously dealing with things in China, or that's not a workable solution. But if you can prevent things coming in from the border, that kind of just solves the, it's just like fixing the disease versus the issue I get, or providing what am I trying to say? I'm trying
the symptom.
Fixes a symptom versus the adjustment, but it accomplishes the same thing. So I think that's a good solution. I don't think a lot of people were aware of that, but ultimately I think having a trademark is something to look into, and for all of you who are considering, I think it's a very, very important thing. So what let's do now, let me go ahead and I'm going to call up, and you'll see me clicking on the screen, I guess, as we go over questions.
Okay.
Probably not sure we'll be able to get to them all. However, what let's do, and if I miss your question, please don't take it personally because we got so many of them. What I'm going to try and do is people have been typing in questions from the very, very beginning here, so I'm going to scroll back a bit, and if we find that we're not if we're not getting a question here again, just please type it in again a second time.
Okay.
All right, and I'll just read these off to you if you just want to answer them as is. Or can you see the questions on your screen?
I can't. Well, let me see. Oh, I bet I can if I can close.
I don't. Hey, I'll just read them to you. Then don't worry about
it. Sorry.
So Lee's question here says, "We are trademarked and trademarked within the state. What does this mean for us?" So I guess he's really asking. Trademarks, I guess, are national, but they're not international. Correct? I guess that's what he's asking.
Oh. Yes. Now, did he ask the state, or did he say?
Well, it says we are trademarked. Well, I know Lee's in Louisiana. It says we are trademarked within the state. What does this mean for us? And I presume he's talking, does it work outside the state? I guess.
Right. Okay. So I kind of feel like, and maybe I'm a little bit biased here because I'm such a gung-ho federal registration kind of girl, but I feel like state registrations are a little pointless. Now, I don't know how much it costs in Louisiana. In the state of Kentucky, it's $10, and you kind of get what you pay for. Basically, what happens is your rights, if you get a registration in your state, your rights will only exist within the state and still only at common law. Now, if you get a federal registration, of course, that's going to protect you in the entire United States, Alaska, Hawaii, of course, and I think Puerto Rico too, actually. So it's a much, much more robust registration. Now, I can't speak specifically to Louisiana or any other specific state because I'm not barred in those states. But that's sort of, my take on it. And of course, if you do file in the U.S., you are extended just jurisdictional presumptive rights within the U.S. borders. And if you want to file in the EU, you're going to need to extend, an application into the European Union. The good thing is that there is a European Union application process, so you don't have to file in each country of the European Union.
Okay. All right, good. All right, Roy's asked a question, and this is, I guess, from a couple of slides back where you're talking about serialized. He's asking what that was, or if you could elaborate on that, please.
Sure. I kind of just threw that out there because, honestly, I don't have any clients that are currently doing this, and it's something I kind of just came across in the last month as a recommendation to help. But basically, if you think about how, I'm probably using not the best example, but if you think about how Apple will use a unique identifier on each of their products, and this is where you're getting, you are getting more advanced, and you are getting, more expensive methods of protecting, your brands, but an actual serialized number that is unique to each product that is engraved on your product, just like your Apple iPhone is. Okay. And that's what I'm talking about with respect to serialization.
Okay. I would say for 99+% of Amazon sellers, that's not necessary, as you said, for different type of scenarios. But it's good to know that, again, just by putting this means putting a serial number on the product.
Right, right.
That's a doable option in protection. All right. Gary has a question here. It says, hi, Susie, can a foreign entity who is currently conducting business in, say, Canada or Mexico, but not yet doing so in the United States, still register as trademark with the USPTO prior to commencing business in the USA? And I guess he's asking, really ultimately, can you do your trademark before you sell your product?
Hey, Gary, thank you. That's a good question. Yes, you can file a trademark application in the United States. Even though you are located in Canada, you can still do that. Now, to eventually get the mark registered in the U.S., however, you are going to have to show that your mark is being sold in the United States. And what I mean by that is that it's traveling in interstate commerce. So you can, really the threshold and what the USPTO requires is not completely complex, but, you'll want to show your website if you have one, and just show that purchasers people in the U.S. can purchase from your website. So yes, you can absolutely file as a Canadian in the U.S. and not even having used the mark yet. Just keep in mind that you are going to have to show at some point that you're using the mark.
Okay. All right. Jim has a question about how to work in the UK, and I think we just kind of covered that a second ago. Let me go back, and Joni has a question here. What's the cost of registering a trademark?
Okay, so your initial application fee with the USPTO is about $275. That price will fluctuate depending on the number of classes that you include in your application, because it's $275 per class. There's also a filing option of $300.
Back up to different classes, what would that be?
Yeah, so like when you file an application, you have to list the goods or services that are associated with your mark. So, for example, if I filed an application for pillows, I believe that's going to be in what's called International Class 20 or 21. I haven't filed a pillows application in several years, so I can't remember off the top of my head, but it's either 20 or 21, which are classes for housewares. There's also a class for clothing, all types of clothing. So really, all goods and services that you can potentially think of are divided up into these 45 international classes. And for each one that you file in, the USPTO will charge you $275.
So it's just product category.
It's product category.
Okay.
Yeah.
That's you use a lot of words. I use 3 when I can. All right.
Yeah, I like the way you did it.
All right.
Yeah, so it's product categories, exactly. Okay. That's what your classes are.
All right.
Yeah.
Okay. And one of my favorites here, Leigh has a question. She says, I have a hijacker on my listing who seems to be arbitraging from my store inventory to the end customer. The seller limits my ability to change pricing optimization of the limit or of the listing, and I guess she's asking if there's anything she can do from that. Sort of, I guess, just to get the trademark.
Yeah, so this is a little bit more complex situation because it sounds like they're selling one of her products that, it wouldn't necessarily be a counterfeit product, right? Because it's her product. Now, in this situation, it's, again, you have to be really proactive, in my opinion, and this comes down to managing your channels of sale and making sure that you have really tight reseller agreements minimum advertised pricing agreements. Don't be afraid to jack up your wholesale pricing if you need to, that kind of thing. But at the end of the day, someone else can sell your non-counterfeit item on your listing. That's a really hard thing to prevent, except for if you can do it by managing the channels of distribution of your products.
Well, that's the thing where, I mean, I'm in a coaching context. I've dealt with a lot of manufacturers who kind of actually are trying to put in agreements to keep their distributors from also selling online because it undercuts everybody. But for those of us here who are not selling the other outlets, it's really not that big of an issue. And again, here's a question I hope that kind of follows up on that. I think it's very similar, is that should we allow an unknown person to sell our products on another channel, eBay, for instance, using our photos and copy? I don't desire to sell on eBay myself. We've not branded the product, but we plan to. So I guess really, and in that context, if you're making money off of that, I'm not sure I would go after that, because obviously they're using your product. I presume they're just buying your product when they make a sale, because that, again, it's not a counterfeit scenario. It's actually somebody paying retail to buy your product wholesale,
Yes, I hear more and more about this going on. But, I don't know. I can't tell from the question whether or not that person has a relationship with that reseller, but it comes down to having really tight reseller agreements.
Yeah.
And being very specific about how they can, price position your product, being very specific about how they can use your branding and your logo and that kind of thing. So, in some ways it is kind of like licensing, and similar provisions that you would see in a licensing agreement are going to end up being in that reseller agreement. So I would say just make sure you have a really tight reseller agreement with these people that, you're permitting to resell your products.
You don't think there's any agreements and things like this. There are lots of courses out there and teach the sleazy stuff like that. And again, in reality, I've let that go when it happens to me, because I'm getting more sales out of it. Now, if I choose in this example to go to eBay, then I would look to police it at that point, because again, it's not hurting me until I choose to go into that market. So that's kind of some thoughts I have.
Right.
But,
right. And you also have to think about your brand value. I think, is your brand something you want on eBay? You might not want your brand to appear on. Your brand might not be an eBay brand, if that makes sense.
Right. Again, that's where you have to determine as a seller what is best for you and your brand, and then act accordingly, I think.
Yes. Yes.
All right. Here, Glenn has the question. Says, great info, loves the systemized approach. Then he follows up and says, do I have to register separately for U.S. trademarks? Glenn, if you can expand a little bit on that. I don't know what you mean separately, unless you have separate brands, I guess. I don't, if you can type a little bit as a follow-up, we'll get into that. And Ronald's asking here, I guess, really what constitutes hijacking as far as the definition. And, to me, Ronald, hijacking is when somebody comes in and is basically, there are some things that they can do, like if like in our review group and things, when people get a product and they're told not to do this, but if somebody comes in and takes that product and lists it on your item or on your listing, that's to me hijacking. Or when somebody does this arbitrage situation and we're finding it closeout somewhere and put it on there. Basically, hijacking is just them selling on your listing. They've hijacked everything that you've done as a private label seller. So all of these things that we're talking about are things that help prevent that and then fix it once it happens. So, okay. Okay, Martin's got a question here. It says, I was successful getting rid of a hijacker and Amazon took him down for my listing, but 3 days ago, Amazon took down my listing saying that somebody has placed a counterfeit demand against me. Amazon hasn't answered in 2 days. So I need a lawyer to have them pay attention to my case. And again, when we can answer that, the other thing too is I find that if an attorney writes in and you've got your things trademarked and registered and you've done all the things, they tend to listen to you. Other than, as you said earlier, they're not into police issues, because I know the issue Martin's talking about. And when he complained about somebody hijacking his listing, I said they did the same thing to him, even though he owns the listing. So that's the background in that particular situation. So any thoughts on that?
Yeah, of course I'm an attorney, and I'm probably a little bit biased, but I do feel like Amazon is more responsive dealing with attorneys. because they know that we have a reputation when we send a letter of concern or a cease and desist letter, or, file something at Amazon, an anti-counterfeiting, notice. I think they tend to take attorneys more seriously, especially if we use the right language in those types of emails, and they're going to be more responsive. They get probably hundreds, maybe if not thousands, of complaints every single day that they're trying to route to the proper people. So I definitely think that Amazon's going to be more responsive if you do have an attorney help you with that. Now, what you could do is you consider working with an attorney to help you draft that language that's appropriate, and so that anytime that you're dealing with hijackers on your other brand listings, you can use a similar letter going forward. So, you're not constantly having to go to your attorney, write this letter, you can try to do it initially on your own. Now, I did mention, I think about, ramping up your aggressiveness and your tone. So I think that's really important. Like I said, start out nice with, your request, but if Amazon's not responsive, get your attorney in there to send the letter.
Well, and I will say this, and just to Martin, everybody involved, I know, to my knowledge, this particular product was not actually private labeled. So the packaging may have been, but I don't think the product was. Martin, I might be wrong on that. But again, prevention is a whole lot easier than fixing something. And so many people, just for whatever reason, don't brand both the packaging and the product. And if you do that, I think that's the biggest thing that you can do to prevent this before it even gets started.
I agree, and I think that a lot of people are put off initially about the cost of package branding, but I would suggest spending less on product initially and really focus on that the branding of your packaging. It doesn't have to be super complex or fancy. There's a company called Nashville Wraps. I'm not associated with them at all, but I have used them before in the past with some of their packaging. They have very fun, unique packaging, and you could even use something like that that's not, tailored specifically to your company, but you could still have some cool packaging with your logo on it, and having those images of that alongside your product on your Amazon listing is going to be a deterrent for hijackers. It's like I've said, don't make this easy for them. Right. Be a difficult business to list against.
Yeah, I always think of the classic thing, when you have your house and you may not have a security system, but even if you put the sign out front that you're backed by so-and-so security, criminals want to take the path of least resistance. And
exactly.
That's
the reason they're doing this is because they're lazy. Well, they're apparently making money, but don't be an easy target.
I know. Well, and a question kind of follow-up was talking about, her product, I guess, from being resold in other places. And she's just typing here that she has resent some different things and sent some things to Amazon and cease and desist letters. And again, things that you're finding there are not necessarily panning out over time. This is where maybe you might want to contact Suzi and see what her thoughts are on how to do this, because sometimes it's just we take it as far as we can go, and you do need to get somebody involved. So that might be worth just a follow up there and go from there. All right, Jody.
Yeah, I'd love it.
Another question here. It says if we have a logo, we should use a trademark until we're a little established with sales, then file a register, then change that trademark with the R. Yeah, I think you covered that, but if you want to touch on that again, I think she dismissed when the trademark. Or I guess she's asking when you use trademark and when you use the circle R.
Yeah. So when you've chosen your trademark, you can go ahead and use the little TM, and you see it oftentimes kind of written as a superscript or a subscript next to a trademark. You can use that without having a pending application. And like I said, the reason that exists, the reason people use that is because it tells people that this is a trademark. You're putting notice, you're putting third parties on notice that that is your trademark. The R in the circle is reserved only for registered marks.
Right. Okay. And then Johnny says, do you have to worry about hijackers if your logo is clearly a big part of the product? Well, Jody, obviously anything can happen, but I'm just a big believer that if you put it on the packaging and the product, it deters most people. And then if it still happens, you can pursue things the way things are being talked about now. But as I coach so many people, she had a section here about rookie mistakes or things to avoid. the two biggest things I see people not doing is spending enough money on their pictures to have it convert well. And the other thing is they won't put packet or private labeling on the product. Maybe they cheap out and put a sticker on a box or something, and it looks like a generic product, and you're just inviting people to go to Alibaba and find the supplier and reproduce your item and then sell it on your listing, because they're assuming if you're not going to go to the effort to private label it, you're not serious, and they know you're not trademarked. So if you're not trademarked, you technically don't own anything. So again, that stuff can happen, I guess, but hopefully it answers that. And
can I say one thing, Mark, that's a little bit, maybe a little tip? This is an example, okay? I don't know how many of your listeners would have this going on, but like if you have something that's a plastic mold, for example, that's integrated into your product, have your mold reworked slightly so that your logo is actually part of the mold. Does that make sense?
Yes.
Yeah, so that's one thing you can do to make it more difficult for anyone to counterfeit or to have any knockoffs. And of course, like you could consider like using like a branding iron or something like that. Literally a brand, on your product if it works with your overall aesthetic, look of your product. So just a little tip.
It's funny. I've actually been looking into all different types of labeling equipment, everything from laser engravers to printers to, I don't know what you call them, but specialty printers to be able to print on metal and things like that, to be able to control some of that myself. Because, again, I just think that's so important to be able to label both the packaging and the product. But, we get to that, I guess. But, all right. Okay. And Layla keeps typing in. Like I said, just, for all the things you're typing in and this lad, just contact Susie, because I think she might be able to help you on getting this removed, since you don't want to have these people reselling your product. Glenn types in, do I have to register my brand to sell it with? I guess he's asking in the case, do I have to register my brand to sell in the U.S. with the USPTO, as well as having to register to sell in the UK with a trademark.gov? I think we kind of covered a little bit of going into both, but I guess you have to register in both places if you're selling.
Yeah. Well, keep this in mind. A registration does not grant you rights to use the mark. Okay, so a lot of people think if I don't get a registration, oh crap, I can't use the trademark. That's really not what that U.S. registration is giving you. It's giving you presumptive rights to the mark. So it makes it easier to get rid of infringers if you need to. So I think that a lot of people get confused on that, and they think that if they don't get a registration through, that's they can't use the trademark. So just keep that in mind, that you can use a trademark without getting it registered as long as you're not infringing someone else. Now, with respect to the UK, yes, you will need to file separately in the UK. And currently, the UK is considered part of the EU. And you'll be able to file in the EU and designate the UK as part of your filing if that would be, of interest to you. And in some situations, it is less expensive to file in the entire EU and designate the individual countries that you want protection in. I'm not sure how things are going to work out in the UK with the whole Brexit thing, so I'm probably getting a little off topic there with that. But just do keep in mind that you will need to file separately in international jurisdictions if you want protection there.
Are the costs roughly the same to file in Europe than what they'd be here?
They're more in Europe. They're more expensive. Trademark attorneys tend to be more expensive in general in the European Union. That's been my experience. But you're looking at it being just a little bit more expensive.
Okay, so that's a vast difference, or what? I bet it's
not a vast difference. It's not a vast difference.
All right, and I hope I'm pronouncing this right. And those of you know, I can't go a single webinar without mangling a name, and it's so important to me to try and pronounce names correctly. So if I'm doing this, I'm sure I'm wrong, but I'm trying here hard. So I'm gonna say Ibrahim, I-B-R-H-A-M. I'm sorry. I know. I'm sure I mangled that. I hope you're laughing right now because I did mean well. But he's got here and everything. He's a manufacturer of a product. It says, as a manufacturer, do I have the right to report hijackers directly to Amazon? I would think yes, but Susie, you want to address that?
Oh gosh, absolutely, Ibrahim. I'm probably
hopefully one of us got it right.
I don't know. I apologize also. But yes, if you don't have to be the owner of the product or the manufacturer, anything to report a counterfeit item on Amazon, and I mentioned this earlier, help your fellow brand owners. If you see someone hijacking or, selling a counterfeit item and you think it could, damage someone else's brand or, a consumer, an Amazon consumer could end up getting the wrong product, report it. Report counterfeit products.
All right. Well, all right. We got time for a couple more here, but like I said, Johnny says, what was the name of that Nashville packaging company you're talking about?
Okay, so it's called Nashville Wraps, and I think the website's nashvillewraps.com.
I would presume that's not like Nashville, like country western rapping. I presume that's WRAP.
Yeah, what kind of rapping would be going on in Nashville? You never know.
A rap song.
It is a sort of a mecca for music, if you're, for country music. But you're right. It's WRAP. And like I said, if you all email me, and I mentioned that I had like that 15-point checklist. I have them listed on there as a source for packaging, and I have a few others too.
All right.
And like I said, I don't have any like affiliation with them or anything. I just use them, and they had a really quick turnaround, and I was pleased with them.
All right, we got time for one more, which I was saving. Which Ruben actually has a microphone, so he wants to ask his question live. So Ruben, let me see if I can figure out how to get you here. Get you on here, and let's see here. Let me find you here, because we got a long list of names here, Ruben. So give me a second here, and I'll see if I can find you. If not, we'll have you maybe type it, because there's a long. Ruben, let's do this. If you could, just type your question. There's several hundred people on the listings here. So instead of me scrolling down with all that, if you just be so kind, just type your question in, Ruben, and we'll hang on and answer that for you. Get the list again. Joyce is asking, how do I get the list again? You mean like a sales listing, Joyce? Is that what? I'm not sure what you mean by that.
Can I tap on here?
Do I?
If she wants the list, I was going to shoot over my email address.
Oh, the list. Okay, yeah, okay, that's you talking about. Okay, yeah. Tell her just you want to announce whatever say whatever that email is, Susie. We'll get her to that.
Sure. Joyce. Okay, so my email address is Suzi, and that's spelled Suzi, and it's at theprivatelabellawyer.com. And don't forget that there are 2 L's between the words label and lawyer, or make sure you use the L twice.
Yeah, I just realized.
I messed that up on my own.
Yeah, this is on my end of the slides now, so.
Yeah. And again, and I didn't have this in the slides, and I thought about it later, the customs, the U.S. Border and Customs website, if you all want to look at that, there's a really, really good video on there about counterfeits, and about how important getting rid of counterfeits is to the U.S. The website is iprr.cbp.gov.
Okay. What Ruben's question is he's asking about an Amazon exclusive seller. Ruben is, I know, a really big volume seller. I think, Ruben, you and I can talk about that later if you want. But, Susie, if you want to just maybe touch on what that program is, Ruben, I think, is a possible candidate for that. So if you can maybe spend a few seconds addressing that.
Sure. Okay, so the Amazon exclusive program, it is a fairly new program. I think it might have started last year, and it's really great for unique products in businesses that really have a story to tell. And I mentioned earlier that Amazon does charge an additional 5% in referral fee for that to be listed as an Amazon exclusive seller, but you really get a lot of benefits from that. You're going to be able to show
your videos and different things on there, so that's a
the video, additional HTML, that you can use. There are some requirements. You have to, of course, be the brand owner of the product. You have to actually have your brand already registered with the brand registry program. you have to, and this is kind of a stickler for some people, but you have to fulfill your product exclusively through FBA, or, well, you have to fulfill it.
You can do it through your own website too.
Yes, yes. You can have your own website. You can have your own brick and mortar, but you can't use other channels like eBay and stuff.
Right.
So,
therefore, the name exclusive. It's your own site in Amazon. So, I think that's smart for Amazon to do.
I think it's wonderful for the the right business, because Amazon, they're incredible at e-commerce. They're sending you the traffic. And I know a lot of people are kind of freaked out about giving up other e-commerce sites, but as long as they're letting you keep your brick and mortar and your own branded website, your own branded e-commerce website, I think it's wonderful. I think it's definitely something that people should consider doing. It's just one more step in protecting your brand as well, and not having to worry about the hijackers.
Absolutely, absolutely. Well, I know we're running a little bit long. I'll let it run long because I think the information is so good, and I can always tell because the vast majority of people who came on have stayed, which usually people come and go during webinars, but people have been here from the beginning, so I've let it go because this is obviously very helpful and valuable to people. So, with that said, I want to make sure go to Suzi's. It was Suzi at theprivatelabellawyer.com to get the checklist. Is that correct?
Yes.
All right. You just email that back to them. All right. The other thing on here, again, it's the Private Label Lawyer. And again, if you need anything, on this, I would feel very comfortable using her for whatever your issues are. So, contact her for your legal needs, if you will. And with that said, Suzi, anything else you want to say before we shut down the webinar?
Just that I really appreciate you giving me this platform to talk with people about private labelling and brand protection and trying to get rid of these horrible hijackers. They seem like they're just coming out of the woodwork. It's like guacamole or whatever it's called. Trying to get rid of them. So
I know. We just can't reach through the screen and just shoot them. That's what I think we'd all like to do. But this is the next best thing, I guess, because this is obviously finding products, and all these things are obviously important in our business, but I think that's kind of step one. Step two is managing your business, and just for everybody going forward, that's where we're going to put a big push on things from my content and things going forward, because I think that's something that a lot of people are not doing as well as they could, and I think part of protecting your brand is a big, big part of business management. So anyway, Suzi, I appreciate you coming in, taking the time to talk to us, because I think a lot of people have certainly benefited from this, and we're getting lots of thank yous now. So Melanie says, thank you much, Suzi and Mark. Will the replay be available soon? Batuli says, thanks. Carla says, or Mark and Suzi, thanks. Thank you very much. I always enjoyed the thanks, and because people are so kind to doing that, because I don't have to type that in. So I appreciate that, everybody. Says, thank you. I'm sorry, go ahead. I was talking. Go ahead.
I just said they're very, very welcome. My pleasure.
Yeah, okay. All right. And Brady, Glenn, thanks. Everybody's jumping on the thing now. Jiangxi, the whole, one of the things here too is, it's always rewarding to me is that we got people from all over the world who come to these webinars. And one of the fun things I do from time to time is ask where everybody's from. And it's just amazing to me that we're so fortunate to be here in the United States when it comes to economic things, but so many people from around the world are taking advantage of that well. But again, Gary, Lee, so many other people saying thanks. So again, if I missed your question, I'm truly sorry. I got to all of them that I could. We had a whole bunch of them. Some of them were a little repetitive, so I didn't get to. But with that said, let's go ahead and call it a day. And I thank everybody for being here. And thank you, Suzi, very much for the time. And look forward to next time, everybody. Thanks. See you.
Thanks, Mark. Have a great day.
Okay, thanks. Bye-bye.
Bye-bye.